like a few minutes late, another document actually hit the docket, like right as I was about to click go live. I was like, oh, let me just refresh the docket. And there was another filing. So we have 2 filings to go over today. And this first one definitely is a big one. Yeah. Hello, Monica. Shout out to the mods in the chat. Sarah, hello. PM, hello. Amber. I'll get to a few more shout outs in a little bit, but let me pull this docket up. So here's the docket. Today's Monday, December 16th. So 2 documents, as you can see, already been filed today. Document 113 and 114. Opinion and order is the first one. Now, what is this opinion and order for? A motion, the motion for a hearing that Diddy filed as to the discovery and evidentiary hearing. Okay. Now, not to bury the lead, it's denied. Okay. Denied. But if you want more details on specifically like what I'm talking about, I have the document. It's 5 pages long, document 113. So, hello. Let me pull that up. Okay. So here it is. Okay. So defendant Sean Combs as Diddy moves for discovery and an evidentiary hearing. On what grounds? Alleged government leaks of case information. So Diddy and his lawyer, Mark Agnifilo, were saying that the government, the feds, had leaked information. Okay. There was other stuff. There was other grounds for which Diddy applied for the hearing, and that had to do with the legal notes. So I'm wondering, I haven't even read this. I went live as soon as I saw it. I'm wondering if the judge is also going to have a category in here about those legal notes, or if these are going to be bifurcated as 2 separate issues. We will see. We should have more information. Hey, Diamond. We should have more information as we read through. So let's see. Diddy alleges that the government primarily through the Department of Homeland Security, this is what Diddy alleges, okay, that the government has engaged in a 7-month campaign involving strategic leaks of grand jury material. Okay, so this is Diddy's allegation. The government has engaged in a 7-month-long campaign involving strategic leaks of grand jury material. The judge says right now, the motion seeks discovery and an evidentiary hearing related to the alleged leaks. Although Diddy forecasts that he might also ultimately ask to have certain evidence that we're discussing here dismissed of the indictment. While Diddy identifies numerous alleged leaks, the judge says the heart of his dispute with the government is a 2016 video from the Intercontinental Hotel in Los Angeles that Combs allegedly was leaked by the government. That Combs alleges was leaked by the government and broadcast on CNN. Okay, so the judge is like, all right, Diddy makes a lot, he squawks, he's doing a lot of squawking, but like, let's be honest, the heart of Diddy's dispute with the government has to do with the 2016 CNN video at the Intercontinental Hotel. I would agree. I agree with the judge on that. That seems to be the main primary issue that Diddy has a problem with. Federal Rule of Criminal Procedure 6E states that a matter occurring before the grand jury must not be disclosed by an attorney for the government or any government personnel. Okay, so he's just kind of reciting the rule. We all know this, or maybe you don't, but Criminal Rule 6E, a matter occurring before the grand jury is, supposed to be a little bit confidential, supposed to be a little bit secret, a little bit, insofar as what the government is allowed to talk about. It says it must not be disclosed. If it happened in the grand jury, it must not be disclosed by an attorney for the government It also cannot be disclosed or must not be disclosed by, quote, any government personnel that an attorney for the government considers necessary to assist in performing that attorney's duty. Okay, so it's like an indispensable party, right? Like somebody that the attorney, they couldn't even do their job without this person. Okay, so that person also cannot go blabbering about details. To obtain an evidentiary hearing, and remember, this is the judge is writing this. To obtain an evidentiary hearing on an alleged breach of this rule, so this is what Diddy would have to show. If Diddy wanted to have a hearing, which is what's being denied, the judge saying no, he would have had to show the following. He must establish a prima facie case of a violation. In determining whether the showing has been made, the court will look at the following factors as well as other additional factors. Okay, so what are the factors the court was looking for Diddy to have gotten to go all the way to this hearing? Because what the importance of this hearing is, well, I mean, there's a lot of importance, but this is where Diddy and his lawyers were going to try and keep the CNN footage out. They were going to try and do that. I mean, they would have had to go to a whole hearing. It would have been like a miniature little trial. The judge saying, no, we're not even going to make it that far because y'all haven't even laid out enough evidence to show why you're just making bold-faced, bald-headed allegations. No hair, no teeth, bald, toothless allegations, the judge is kind of saying. Well, I mean, that's what I think he's going to be saying. I did kind of skim. To obtain an evidentiary hearing, Diddy and Agnifilo should have been able to make a prima facie case of the violation. And this is what the judge was looking for according to case law. Here's the factors. One, whether the media reports disclose matters occurring before a grand jury. Okay, determining whether the required showing has been made, the court should examine whether the media reports disclose matters that are occurring before a grand jury. Okay, so first of all, you need media reports, and the media reports have to make a disclosure. They have to actually do something, say something. And what they have to disclose is specific. It's not just anything. It has to be matters that are occurring before a grand jury. Okay, that's first factor, but that's not the only factor. There's many. What's the second factor that the judge is going to be looking for and was looking for in determining his decision here? It was, quote, whether the media report discloses the source as one prohibited under Rule 6E. Okay, so we're worried and concerned with number 2 about the source. And was the source of this information like the government itself, or did the source come, from somewhere else? Did maybe a bodyguard or some random person or someone come and leak? The third factor is evidence presented by the government to rebut allegations. So the evidence presented by the government is one of the factors that the court needs to consider. Okay, so then they're quoting case law here. The defendant must make a prima facie case showing that there's been a disclosure of a matter or matters occurring before a grand jury and that the source of the disclosure was an attorney or agent of the government. Okay, so this is another way to put the same factors. They broke them into 2 here. It's, depending on how you put them, you could probably break it into 4. You could break it into 1 sentence, but, these are the things that have to be shown. And the judge is basically just like, Diddy did not do that. Okay, so they're comparing the difference between whenever you're trying to get something, an evidentiary hearing to just kind of get rid of some evidence versus whenever you're trying to get the whole entire everything case dismissed. Okay, so they're making a little distinction here, but I don't know why it's going to matter yet. The judge goes on. As to searches of Diddy's homes, okay, so now we're talking about the homes searches. So earlier, hello, if you're just joining, hello, I did ask earlier whether the judge was going to address multiple issues. Here's one right here is the searches, right? Because Mark Agnifilo and Diddy based their arguments for this hearing on a few things. They wanted the judge to let them talk about a few things. One thing was the leaks of the CNN tape, okay? So, in addition to the leaks of the CNN tape, there's some other stuff the judge is going to address here in this order that just hit the docket like within the last hour, I think. I mean, I saw it just recently. As now we're talking about the searches of his homes. Remember, Diddy and Agnifilo had said that it was like unconstitutional search and seizure, and they handcuffed the sons who were not even named as defendants, all that, right? They were all upset about the searches and the ransacking and all of that. Okay, so now the judge is going to talk about it. Like, you're not getting a hearing on that either. Diddy argues that the presence of media on the scene made it, quote, clear that the Department of Homeland Security alerted the media prior to the search in order to maximize exposure. So this is what Diddy had claimed. The judge is quoting that. But of course, the searches, which were executed pursuant to warrants, were not themselves matters occurring before a grand jury. Okay, so the judge is saying, all right, so sure, maybe the media was there and all of that, but we have to only limit this decision and this discussion to, quote, matters occurring before the grand jury. And the judge is saying here in this case, you're mad about searches of homes and stuff and alerting media and leaks, like leaking to the media, leaking to the press that there was going to be a search. The judge is like, even if the government did do that, the search outside in plain open daylight is not in and of itself qualifying for matters before a grand jury. The judge probably going to say, because it happened in public. I don't know, whatever. We'll see what the judge says. But this is basically saying you're not going to get past me on something having to do with these things, having to do with these searches, because those are not quote, matters occurring before the grand jury for the purposes of case law and statute. Let's read the judge's reasoning. Combs, that's Diddy, provides no basis to suggest that there has been a violation of Rule 6E here, okay? So remember, the reason we're talking about Rule 6E and why it matters at all is because this is the exact statute that the judge is having to interpret in making his analysis on whether to move forward and allow Diddy to have an evidentiary hearing, which would also allow him to collect all kinds of information from the government and maybe communications and stuff like that. The judge is putting a stop to it. He's saying no, and he's basing this decision on federal rule of procedure, criminal procedure, Rule 6E. The judge says, I have to go by Rule 6E. And in order for Diddy to satisfy his job, his burden under Rule 6E, he has to suggest that it was violated. But he doesn't. He doesn't even suggest that there has been a violation of Rule 6E whenever it comes to providing the basis for his arguments. Okay, let's see. Okay, so he cites some case law. This is the judge. He's basing his decision on at least two cases. One is called Skelos. Maybe it's both from that case. Okay, so it says the rule is not violated by disclosure of a search warrant affidavit. Okay, so just disclosing a search warrant affidavit is not violating Rule 6E. Even if that information might later be presented to the grand jury, where it was obtained independently. So we're talking about, how did the government get the information? The government might have got that information from the grand jury and leaked it. And that's what Diddy is saying happened. But isn't there another way the government could have got the information? What the information we're talking about is the fact there was going to be a search. And then the media showed up and videotaped Diddy and his kids and stuff. The judge is saying, how did the government find it out though? Because if they were just watching, if they were just searching for affidavits, that's public. So if an independent party could have found that information anyway, it's not leaking as far as the purposes of this law. And then it goes on to say, quote, information produced by a criminal investigation that parallels but is independent of a grand jury investigation. So it's two grounds the judge is basing this part of the decision on. The government could have got this information from somewhere else, including the news, and also including they're doing their own investigation elsewhere that has nothing to do with the grand jury investigation. Okay, so the judge goes on. As to the Intercontinental Hotel video. Okay, so now we're going to be talking about the Intercontinental Hotel video. Okay. The judge says Diddy has not carried his burden to show that the government leaked it to CNN. Diddy had a burden. He had a job. He had, a certain, a burden to bear, and he did not bear it. He has not carried the burden. He had to show the government leaked the video to CNN. Diddy argues that, quote, the most likely source of the leak is the government. But he doesn't point to any sound basis for this conclusion. So he's just making a bold-faced allegation, but he's like, what do you mean the most likely source? What do you mean? Where's the basis for why do we have to believe that's the most likely source? Diddy lists 4 reasons for accusing the government. Okay, so the judge saying there's 4 reasons that Diddy lists for accusing the government. And oh man, this is bad. The judge said none of which are convincing. Or which is convincing. Okay, so what were Diddy's unconvincing reasons for accusing the government of leaking the tape to CNN? First unconvincing reason. Diddy argued that, quote, federal agents had already engaged in a months-long campaign of leaking information to the press by May 2024, when the CNN video was leaked. And so they had a, quote, demonstrated propensity to make such leaks. Okay, so this is one of the reasons. One of the reasons that Diddy said that the government was the one responsible for giving CNN the tape in the first place is because federal agents had already been doing this leaking for months, and this just shows that they just kept doing it. But the judge is like, no, that doesn't work. His second reason the judge goes on to consider. Diddy says that victim 1, that's largely believed to be Cassie. This is the person from the CNN video, so we think it's Cassie, right? I mean, I do. Think for yourself. Second reason Diddy gives, though, for saying that the government is the party responsible for leaking the tape to CNN, because we don't really know who gave CNN that tape. Diddy saying, well, it had to have been the government from the grand jury, and because of that, I should get a hearing. And the judge is like, no. What? No. He said Cassie is not a likely source of the leak because there's no evidence she had access to the tape. And she had no motive, quote, no motive to approach law enforcement after receiving a substantial 8-figure settlement from Diddy in another case. Okay, so this is Diddy's second reason why the government was the most likely source of the leak of the tape to CNN. Is that Cassie is unlikely to be the person that leaked it because she had no motive to do it because all she was after was money, and she already had her money and all that. So the judge is like, no, sorry, Diddy, absolutely not. That's a bad argument. Okay. So what other reason? Because all of this comes back to the fact that Diddy had a burden here under the rule. The only way he could have proceeded forward to get a hearing at all and to get this little discovery and all this, the only way he could have proceeded forward is if he met his burden. And his burden was to show that the government leaked information. And the judge is just annihilating all of his arguments. The judge is saying, no, there's no proof the government leaked this stuff. And so for that reason, I cannot give you this hearing. No, shut up. The third reason Diddy tries to hang his hat on and make his arguments based on is, quote, Combs surmises that a, quote, unrelated third party is not a likely source because such an individual would have sold the video. I forgot he said some of this stuff because some other person would have sold the video instead of simply giving it to CNN. Okay, this is such a stupid reason. It's like the judges that are really good, they have such a clear and straightforward way of showing you how stupid and illogical the arguments are. The judge says to Combs, the leak showed a, quote, motive other than financial profit. And that was to damage Sean P. Diddy Puff Daddy Combs' reputation without remuneration. And finally, Diddy suggests that the, quote, timing of the leak points to a government source because federal agents would have known that May 17th was a perfect time. Due to the break in the Trump trial for Barron Trump's high school graduation. Oh, Diddy was like, and they would know because they would be in their schedule books because they would know Barron Trump was graduating. And they were like, the judge is like, nope, it's not convincing either. The judge says, in response, the government insists that it was not in possession of the video when it was aired on CNN. The government also insists that the video wasn't procured through the grand jury process. Remember when the feds came back and they were like, Your Honor, all that's fine and good. We didn't even see that freaking video in the grand jury. It never came up. First time we saw it was CNN. Department of Homeland Security agents are also unable to issue grand jury subpoenas on their own. I don't know what that has to do with anything. I'm sure it's meaningful. The government says it obtained a copy of the video at the same time as everyone else when CNN released it. Okay, so that's what the government says. And Diddy had a burden to show somehow either undermine that story, show some type of false thing about the story. Like he had a burden to show differently. The government rightly points out that Diddy never considers the possibility that many people beyond Cassie and government agents likely had access to the video, including Diddy's team, who paid security officers at the Intercontinental Hotel. Remember, whenever the security officers are the ones who are purported to be the ones that gave money, that basically paid off the hotel. So, hello, well, how does Diddy know that those people didn't make a copy or, whatever? Also, it could have been hotel employees or contractors. An ex parte submission by the government. So the Fed submitted something to the judge, which the court considers after in-camera review, presents. Okay, so the judge looked at something out of the public eye. The judge we're being informed, the public is being informed right now that the judge has seen something in camera, meaning we haven't seen it. He has seen it. And the judge says that what he has seen presents compelling evidence that CNN's source was not, in fact, the government. Okay, so the judge, we're just going to have to take his word on it, I guess. He says, importantly, nothing in CNN's presentation of the video even hinted that the source was a government agent. So also the judge is saying also whenever CNN aired it and presented the video, they didn't say or hint or have any indication at all that anything they were doing was part of connection with the government gave it to them. They weren't like, oh, this was leaked by a government source, for example. The judge goes on. As to the interviews and the quotes attributed to law enforcement agents, none discloses, quote, matters occurring before the grand jury. Combs doesn't identify a single article with government sources disclosing grand jury materials, despite telling the court that several of the leaks explicitly mention grand jury proceedings and the grand jury's ongoing investigations. Okay, so this is might be strike like 4 or something for them, because the judge is going out of his way and making it a point to admonish, in my opinion, Diddy and Mark Agnifilo and Alexandra Shapiro. The judge is saying Combs doesn't identify a single article with government sources disclosing grand jury materials, despite the fact that he did tell this court, seemingly, falsely, that, quote, several of the leaks explicitly mention grand jury proceedings and the grand jury's ongoing investigation. Diddy argues that matters occurring before the grand jury should be construed broadly to include, in addition to evidence actually presented to them, also wants to include all this other crap, including anything that may tend to reveal what transpired before it, and including summaries of grand jury testimony. The judge says, but again, no information is attributed to law enforcement or government sources in the articles. The judge is like, I have searched high and low. I've searched high and low. I don't see a single article that y'all gave me, Diddy and Agnifilo and Alexandra Shapiro. I did not see a single article that actually disclosed matters occurring before a grand jury. Despite the fact that y'all represented in my courtroom to me that that's what we were going to be looking at, I didn't see it. Instead, the judge says, the articles discuss the searches of Diddy's homes, what was found inside, previous allegations against Combs, the charges against him, and the government's future investigatory plans. All of this is part of the ongoing prosecution and not necessarily the grand jury investigation. And all of this can be gleaned from the indictment, and none of this is a violation of Rule 6E. Official statements about the investigation, statements in open court, and search warrants are all fair game, the judge is saying. The Second Circuit has been clear that information about a criminal investigation is not covered by Rule 6E, and y'all gotta tell me how they broke Rule 6E before we can ever get to a hearing. There's a difference between statements by prosecutor's office with respect to its own investigation and statements by a prosecutor's office with respect to a grand jury's investigation. And it's a distinction of the utmost significance. In cases where federal courts have found violations of this rule, the violations were closely linked with improper disclosure of the inner workings of the grand jury, not simply information about some aspect of a related government investigation, which in this case would be the grand jury investigation, because there is still an ongoing grand jury investigation from what I understand. And they could, based on that ongoing grand jury investigation, still do like a superseding indictment on Diddy. They could still add defendants. They could still expand the scope of the charges. They could add more charges. There's a lot of stuff. Just as in Adams, the articles here, this is the judge saying, look, here's this case that I have to follow because it's precedent, Adams. So this is the case like in Adams. The articles here reference investigations generally, but they do not identify these investigations as grand jury investigations or investigations into matters before the grand jury specifically. And none of the articles expressly or by implication identifies the source of the alleged disclosure as a prohibited source. Not all law enforcement agents or government employees are subject to Rule 6E. And I think this is very important. The judge says, you can't just bring any and every claim before me because somebody that works for somebody's government said something. The rule does not apply to everybody. It only applies to some people. Only government attorneys or agents with whom grand jury information has been shared are subject to this Rule 6E secrecy requirement. As the government points out, the judge says, none of the cited articles indicate on their face that any leaked information came from the prosecutors or the agents conducting the investigation who had access to the grand jury materials. So the judge is saying, yeah, look, I mean, the government said, Diddy, prove that it came from us and not somebody else. And Diddy was unable to do that. News reports that merely identify a government source or a law enforcement source and not government investigators to Rule 6E, this is not a violation. The judge says similarly here, no article that Diddy is huffing and puffing about states that its source is a prosecutor or an agent with access to grand jury material. The articles that come closest are the ones that cite Department of Homeland Security agents who helped raid Diddy's home. Okay, so the judge is saying the closest that Diddy gets, the best argument he makes, is when he's talking about the Department of Homeland Security agents who were there and present and helped to do the raid in the Miami raids. This would have been back in March 2024. The judge says, but even if this is true, only those DHS agents given access to grand jury materials are covered by Rule 6E, and there's no evidence that the DHS agents cited as sources were among those with access. So Diddy said so the judge says, yeah, okay, Diddy gets close, but he misses because he needed to say, and in addition to all of this, oh yeah, they said some people raided my home, DHS agents. He needed to show or at least allege that those agents had specifically had access to grand jury material, which he did not do. Nothing in what those agents supposedly told media outlets is clearly from or relating to a grand jury proceeding. The judge gives an example. He said, for example, the claim that there were rooms at Diddy's house solely dedicated to sex with cameras planted all around. The judge says that quote could have come from the agent's execution of the search warrant. The statement that, quote, in my opinion, he's as bad as J.E., that is an opinion presented as such, held by an alleged agent that doesn't reveal any particular information from the grand jury proceedings. So there's two things, the judge has given two examples. He's like, hey, here's two things Diddy was upset about. One was one of these alleged agents that helped do the raid said that there was rooms solely dedicated to sex and there was cameras planted all around. But the judge said that could have come from another source. And then he gives the source, for example, an agent's execution of a search warrant. That has nothing to do with being in front of a grand jury until it's in front of the grand jury. And the statement that, in my opinion, he's as bad as J.E., the judge is saying, you're allowed to say your opinion. It's not like he said I was in the grand jury and he's as bad as J.E. He said, my opinion, he's as bad. And that's allowed, the judge is saying, which we all know. The judge says this analysis includes the two New York Post articles highlighted in Diddy's reply, one published before but on the same day as the court's order, and the other less than a week later. Both involve federal law enforcement sources who claim some familiarity with the investigation. Okay, so the judge is saying, all right, so then Diddy wants to talk about these two articles. They show up in the New York Post. And they talk about federal sources claiming some familiarity with the investigation. The judge says, but neither one of these discloses information that could not have otherwise been gotten from a non-grand jury source. So this information could have been, again, from a search warrant, from something else. The quotes in these articles that Diddy finds most objectionable reflect statements that don't themselves reveal any particular facts, rather than subjective opinions, and certainly not particular facts from grand jury proceedings. So Diddy's just upset about statements, but he's not meeting his burden to show, or at least even allege, that this stuff is came from grand jury. It was secret. It wasn't out in the warrants. It wasn't anywhere else. The government also submitted an affidavit from Jane Kim stating that and this is the deputy chief of the criminal division in the SDNY where this case is being charged. This deputy assistant stated, after she discussed the matter with the prosecutors and agents assigned to the investigation, they each affirmed that they have not disclosed information they learned during the course of the investigation to any member of the press. Such affidavits are frequently considered by courts in this district when assessing whether there has been any Rule 6E violation. The court is sensitive to Diddy's concern about the publication of stories claiming to disclose inside information about this case from unnamed federal law enforcement sources who were involved in the investigation. Okay, so the court is saying, just because I'm denying your motion doesn't mean I don't hear where you're coming from, Diddy. He said, I'm sensitive to it, that there's publication of inside information publication and disclosure of inside information about this case from unnamed federal law enforcement sources involved in the investigation. The judge says, I hear you, Diddy. I hear you. Says the court has already taken steps in this regard, though, and it is open to tailored applications for relief as this case continues. Okay. So the judge is saying, and this is not the first time we've seen him do this. He's saying, I hear you, Diddy. I hear where you're coming from. Just because I'm denying your hearing doesn't mean, I don't hear where you're coming from. I'm sensitive to your arguments. And if, there's unnamed law enforcement sources, we've already done a gag order. So hopefully that tailors that. I don't think it's happened since. He says, and also, just because I'm denying a hearing doesn't mean that I'm denying changing a little bit, something here, there, and everywhere about it. You know what I mean? Come to me with more specifics other than, I need a whole hearing. And I can change the gag order. I can admonish. I can sanction whatever I need to do. But we're not going to be doing a hearing. No. Go get ready for trial. The court once again reminds the government and its agents that if specific information comes to light showing that they leaked prohibited information, action will be taken. All right. So the judge is saying, just because I am not giving Diddy a hearing doesn't mean that I wouldn't give him a hearing if he came with some evidence. Okay. So just as soon as he comes to me with some evidence that y'all leaked something, we are doing a hearing. Action will be taken, he says. I don't know if that means he's going to do a hearing or not. Action, quote, action will be taken. And the court reminds the public. Yes, look, the judge has a special announcement to us. Thank you. He's speaking to we the people. This is a monumentous occasion. Let's see if he's fussing at us or if we already been doing what he's been telling us to do. I haven't read this sentence. The court reminds the public. This is the message to the public from the judge. I don't know. This is pretty cool. This is pretty cool. He's talking to us. Let's see what he has to say. The court reminds the public that whether the government can prove Diddy's guilt in this case will turn on the evidence presented at trial, not trial by newspaper. Not in a trial by newspaper, the judge said. This is pretty cool. Put a 1 in the chat if this is pretty cool. I mean, we already know this. We do this every day on this channel. We're doing a media analysis every day over here. What is going on with the light? The court reminds the public, straight from the judge right here, signed today, whether the government can prove Sean P. Diddy, Puff Daddy Combs' guilt in this case will turn on the evidence presented at trial, not in a trial by newspapers. He quotes this Pennicamp case, quote. Well, this is an old one. This is a precedential one, 1946, quote. Cases are too often tried in newspapers before they are tried in court. And the cast of characters in the newspaper trial too often differs greatly from the real persons, this is good, who appear at the trial in court and who may have to suffer its distorted consequences. This is powerful. The judge issues an order to us. It is so ordered. I don't think anybody over here has anything to worry about because we are already doing this. We already do this every day with sensitivity and levity. But just one more time, I feel like this is historical. This is historical. This is unprecedented. This is going in somebody's book, if not more than a few people's. This is going to be on headlines and stuff, this quote. Let me see the whole paragraph. The court is sensitive to Combs' concern about the publication of stories claiming to disclose inside information about this case from unnamed federal law enforcement sources who were involved in the investigation. The court has already taken steps in this regard, and it is open to tailored applications for relief as this case continues. The court once again reminds the government and its agents that if specific information comes to light showing that they leaked prohibited information, action will be taken. And the court reminds the public that whether the government can prove Sean P. Diddy Puff Daddy Combs' guilt in this case will turn on the evidence presented at trial, not in a trial by newspapers. Cases are too often tried in newspapers before they are tried in court, and the cast of characters in the newspaper trial too often differs greatly from the real persons who appear at the trial in court and who may have to suffer its distorted consequences. That's powerful. The clerk of court directed to terminate docket 30, so ordered. December 16th, 2024, New York, New York. Judge Arun Subramanian. Sorry. Judge Arun Subramanian. Okay. Well, no, motion denied, but I do think, the judge made it pretty clear. He's not like fully 100%, just all 100%. No, Diddy, this is frivolous. This is silly. He's leaving the door open as he does often. Okay, hold on. Whoa. Y'all are getting really carried away. Goodbye. There's another document been filed. So let me pull the docket back up. Let me see. Hold on. Okay. Letter by USA as to Sean Combs addressed to the judge. Joint letter conference. Okay. So I haven't read this. It's like 1 page long. So let me just pull it up. It said it's a letter about Diddy from the government. Filed also today, just moments before I went live, it went public. Okay. Okay, so it's a joint submission. Oh, wow. I predicted wrong. Wow. The parties, so this is the feds and Diddy. The parties respectfully submit this joint letter in response to the court's order dated December 12th, directing the parties to outline the issues the parties believe should be addressed at the pretrial conference scheduled to proceed on December 18th, 2024. Okay, the pretrial conference, I don't know if this is a public hearing, but there's a lot of stuff going on the 18th. Let's just read what the government is saying. Okay, so this is the government's position on discovery. Government's position. Hold on, let me highlight it. The government is on track to complete production of the discovery currently in its possession by December 31st, 2024. So by the end of the year, by the end of this month, the government is on track to complete production of the discovery currently in its possession. Now, this was previously promised. The government said they were going to have everything turned over by December 31st, and they're saying we're on track to do so. Certain discovery, however, may be produced after that date. Well, those are two completely contradictory sentences, ma'am. Who signed this? Maureen. This is two contradictory statements. What does this mean? We're on track to complete the production of the discovery in our possession by December 31st. Certain discovery may be produced after that date. What? That's two completely different assertions. They give an example. Maybe that'll help clear it up. For example, due to technological limitations, the government has not yet been able to extract every electronic device seized. To the extent that the ongoing efforts to extract the devices are successful, those extractions will be produced promptly. Moreover, as noted previously, the government's investigation is ongoing, and the government will continue to produce discoverable material as it is received on a rolling basis. And then they give an example of this. This may include, among other things, records received in response to outstanding or new subpoenas. Okay, so they're saying everything that we actually currently right now have in our possession, this does clear it up a little bit, thankfully. They're saying everything we have in our possession right now, we're on track to give it to Diddy or Agnifilo or whatever by December 31st, as promised. We're on track. That being said, we haven't been able to hack into some of these devices yet. Some of these iClouds, we still don't know. We don't even have it. Like, we have it. It's in our possession, but we don't have it. Like, it's not known to us. Does that make sense? I think that's what they're saying. They're like, okay, well, so like, look, due to technological limitations, the government has not been able to extract every electronic device seized. What does that mean, to extract the device that was seized? I think it means the data from it, the information, the conversations, the pictures, the videos, the whatever's on it. I don't know. I mean, I'm just reading it from the page right here. This is me trying to, I mean, it's a little bit ambiguous. Exactly what the government has not yet been able to extract every electronic device seized. Could mean a few things. To the extent the ongoing efforts. But the efforts to get the data or whatever to extract these devices is ongoing. And they're like, okay, so we're going to turn everything over to him. And if we get this, that'll be turned over to you. But so far we haven't been able to get it, extract these devices. So to the extent that somehow we can jailbreak or whatever, those extractions will be produced promptly. Moreover, as noted previously, the government's investigation is ongoing, and the government is going to keep getting more new evidence. So everything in our possession right now, we'll give it over to them. But if we get more, we will continue to produce to him, in the future. This may include, among other things, records received in response to our subpoenas. Like, we still have outstanding stuff going on. As we get it, we'll keep giving. Okay. Got it. It's reasonable. Makes sense so far. With respect to the defense statement that it intends to write the court. Hold on. Let me read the sentence. Right court. Wait, with respect to the defense statement that it intends to write the court regarding the government's Brady disclosures to date, the defense raised a question about the government's disclosure letter for the first time. The government would like an opportunity to meet and confer with the counsel. Okay, so I don't know if, excuse me, I don't know if this is going to be further explained or we're going to get some more details on what they're really talking. This is kind of out of the blue for me right here. But the government, first they say, all right, here, Your Honor, here's our position. And the reason they're writing this letter at all is because there's a pre-trial conference coming up. December 18th. So Wednesday. But I think other stuff's happening on Wednesday. Maybe not. Maybe a lot of stuff's happening there. I don't know if that's public hearing or not. The pretrial conference. So the judge had told both sides to submit their issues list of things that they thought should be addressed at this pretrial conference that's going to be happening on Wednesday. The judge wanted it by today. Remember, we discussed that. The judge gave him that deadline. He's like, no, y'all submit the letter together. And I was like, there's no way they're going to be able to put it. They're going to be able to submit a letter together. And now I was proven wrong. They did. They submitted it together. So the government starts out by saying, okay, just to update, Your Honor, on the discovery, because they're about to have a pretrial conference. So just an update on the discovery. We're going to be able to turn over most stuff. There's a couple exceptions. Here they are. And then there's this kind of out of left field paragraph. They're like, with respect to Diddy and Agnifilo and them statement that they're going to write the court regarding the government's Brady disclosures. So Brady, Maryland versus Brady or whatever, is the case that allowed Alec Baldwin to get off in the Rust trial. Okay. It has to do with like government withholding evidence that's material, exculpatory, inculpatory, all that. Diddy and his lawyer have made a statement that they're going to write the court about this type of material. So I think they're trying to get a mistrial. The defense raised a question. So Diddy and Agnifilo raised a question about the government's November 21st, 2024 disclosure letter. So the government had wrote this letter all the way back in November, like a month ago. And all of a sudden now Diddy has taken issue with it. The government says the government would like an opportunity to meet and confer with Agnifilo and Shapiro and them first on any alleged deficiencies before seeking court intervention, particularly given that the government's discovery productions in this matter are not yet complete. Okay. So Agnifilo, I guess, apparently, or Shapiro or whoever, are about to try and get the court to intervene on some Brady material. Brady material is the stuff that if you hold it from the defendant, they get a mistrial. Okay. If there's Brady involved, a mistrial could happen. Okay. So, the government is saying, Your Honor, the Brady hearing is completely premature. We still got to give them the rest of the stuff. How are they going to even say Brady anything if we're not even done giving them stuff? Like, for example, let's say one of the things that Diddy thinks is Brady material is a diary. Let's just say it's Kim Porter's manuscript. Let's just say. And Kim Porter's manuscript is at the bottom of a pile because it wasn't prioritized or whatever. But by December 31st, they're going to send over Kim Porter's manuscript. I'm just giving an example. I'm just giving an example, an illustration. It's fake. I don't know if this is real, but like, let's say, right. And let's say Diddy's like, they haven't given me the Kim Porter memoir. And that means, that's Brady material. I get a mistrial. And the government's like, whoa, dude, chill out. It's like literally have 2 more weeks. We're giving you stuff every day. Are we not? The deadline hasn't even passed. How are we going to do Brady stuff? How are we withholding something whenever we haven't even finished giving you the stuff we have? Is basically what the government's saying. And so the government's asking the judge for kind of like, Your Honor, before you get all worked up over some Brady material and Brady this and Brady that, can we at least give us time to finish? Our deadline that you gave us isn't even here yet. We have weeks left, 2 weeks left. That's what the government's arguing, asking, and I bet you that the judge is going to grant it. The judge is going to stay deciding on anything having to do with it. I think that's what I think. Okay, so now this is going to be the defense position. This is Diddy and Agnifilo's side. The defense intends to file a letter with the court today. Oh, we're going to be here today. Requesting that the court modify the terms of the protective order to require the government to redesignate a small subset of discovery materials currently designated as inspection only to okay, so I was right. Kinda. I wasn't as proven wrong as I thought. He is going to write his own letter. I knew it. I knew they weren't going to be able to do this guy. So wow, Mark at freaking Agnifilo. Or is it Shapiro? Agnifilo. Jesus. The defense. So Diddy's lawyers are going to file today. They might have already filed it. Oh my God. 3333 in the chat. Whoa. Okay. The defense intends to file a letter with the court today, requesting that the court modify the protective order. It's like, that's like the gag order. The protective order about, who's allowed to see evidence, what you're allowed to talk about, who's allowed to look at it. Some of it is attorney eyes only. Some is like attorney possession only. Some is public. None of it's public, I don't think, in this case yet, but there's different designations based on the categories of evidence. Like, for example, somebody's hospital stay records are going to be pretty confidential, or somebody's business records in some cases, or whatever, right? But then versus just like, the CNN tape, like we've all seen it. So Mark Agnifilo is saying, Your Honor, today we're going to file a letter and we're going to ask you to modify. Remember, literally just in the earlier document, the court was like, I'm willing to modify who's allowed to look at stuff, who's allowed to do whatever. Like literally seconds after that hit the docket, Mark Agnifilo is going to take him up on it. He's like, all right, I'm asking you to modify it. Letter coming today, buddy. Because guess what? I want you to redesignate some of this discovery material. Right now, it's under the category, quote, inspection only. I want you to change it. I want you to change it to attorney possession only. We have met and conferred with the government on these materials, and discussions are at an impasse. That means we tried to talk. I knew it. We tried to talk about this, Your Honor, and we're at a standoff. Okay, we need you. Ring, ring. The defense's letter, Diddy and Agnifilo's letter, will also address the government's Brady disclosures thus far, and argues that the Brady disclosures fail to meet the minimum constitutional standards to which Diddy is entitled. This is, what the government was responding to in this paragraph right here. Okay, so the government's like, okay, to the extent that they're going to try to talk about Brady stuff, can we just table that until after the new year so that we can actually give them all this stuff that we have first? So then that would leave, so two issues Agnifilo wants to talk about at the pretrial conference. He wants to talk about changing the designation of an inspection only to attorney possession only. And this has to do with that gag order, protective order, evidentiary protective order. He also wants to talk about Brady material, but the government's like, no, I don't want to talk about Brady material. Can you at least let us freaking get to the deadline first? Let me go to the docket and refresh, because I haven't checked it in about an hour. So I'm going to go over there and see if Agnifilo has filed his letter. It looks like no. Let me just type it, like research for it again, just to make sure. It's 1 p.m. right now. There will be another letter coming today. I imagine they're probably going to have a few things coming today. I imagine there'll be a few filings today, if I had to guess. Or tomorrow, like between today and tomorrow, because there's that hearing on Wednesday, or I'm calling it hearing. I don't know if it's public. It's a pretrial conference. No. Okay. So here's the docket. Most recent thing filed is the letter that we just read. Okay. So Audie has a hearing on Thursday too. So he's Adako, new member. Shout out to you. Shout out to Kimberly in Japan. Blue, thank you for the $2 super chat. Thank you for all you do, and hope you have a great day. Thank you. Hope you have a great day too. Thank you, New Life Plan, for the $9.99 super chat. Observation, you start rebuking and drones start showing up in New Jersey. Are you going to file a report that Lucifer's fans sent them and Lucifer is responsible? Sorry, feeling sassy. No. I think they overhear from my family reunion, to be honest. Thank you for the $9.99 super chat. Thank you, Bats, for the $5. Love a tea time with BJ. Yes. Thanks so much for the $5. In the club we all fam. Exactly. Yeah, so that's all I really wanted to talk about today. Docket number 113, 114. I'll probably go back live again whenever Mark Agnifilo files his letter or whatever. So I also have actually, let me answer this question. Harry Samal said, Hiya, just a quick question. Do you follow Sikhism? Actually, thank you for asking. Okay. I'm not talking about Jay-Z really no more. I mean, who knows? Maybe it'll come up, but this is just a Q&A round. Do I follow Sikhism is such a good question. It's an interesting question that I don't really know how to answer, because I have been learning about Sikhism and like about the different gurus and all that for several years, but I also tangentially have been learning about Hindu philosophy and like ancient texts, which were eventually evolved into Hinduism. And I think that Sikhism definitely resonates with me as much as most religions, could or whatever. I mean, even more than other religions have. I definitely, here's where, I have a little bit of an issue, because like from what I'm learning from like, the actual English translation of like the Guru Granth Sahib and stuff like that, it's like it's kind of like the foundations of Sikhi. It seems to be like a little bit different than how it's being implemented today. Do you know what I mean? So for that reason, I hesitate to associate or align myself with any kind of existing organizational structure of any religion. But what I will say is like the tenets of Sikhism. So like, do I follow Sikhism? It's a complicated question, because, people alive today may say no, because I don't believe certain things or I don't do certain things, etc. But I definitely think it's very interesting, and I believe in the foundations of it as far as I understand it. No, I think the person who said that, you're rebuked. Goodbye. I think the thing that I've learned about it is that it's very, you can like actually have another religion and practice Sikhism in the traditional understanding of it. So like that, even you could be a Hindu and practice the philosophy of Sikhi. You could be a Muslim and practice the philosophy of Sikhi back in, the earlier days of it. So that I think is cool, because it's not exclusionary. It doesn't make you pick one. And once you have to pick one, I don't want to pick. You see what I mean? But anyway, okay. Oh, start. Okay. Thanks so much, Tony, for the 199 super sticker. Okay, I'll be back later, probably once other stuff is filed. In the meantime, facts ain't defamation. I love you, Mika. Bye.